Hi, everybody, and welcome to today's lecture, or seminar, which is co-sponsored with the Refugee Law Laboratory. And before we get started, I just wanted to once again remind us that we are currently located on the land that was caretaken by many people who came before us. We acknowledge our presence on the traditional territory of many Indigenous nations. This area, known as Tkaronto, has been caretaken by the Anishinaabe Nation, the Haudenosaunee Confederacy, and the Huron-Wendat. It's now home to many First Nations, Inuit, and Métis communities, and we would like to acknowledge the current treaty holders, the Mississaugas of the Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, which is an agreement to peaceably share and care for the Great Lakes region. And as I always say at the beginning of these talks, as people who work in the area of forced migration, it's really important to really reflect on the fact that we are on land that was taken through forcible displacement. So just to reflect on that relationship as we get started. I'm really excited to present today's speakers. We have Catherine Tomkodeni-Denler, who holds a PhD in geography from York University. She's a research affiliate with the Center for Refugee Studies at York University here, and a research affiliate at the Refugee Law Lab at York University. Brianna Garneau is a PhD candidate in sociopolitical studies and affiliated with the Center for Refugee Studies at York University, holds a Master's of Arts in Criminology from the University of Ottawa. They are launching a report today called Deporting Refugees, Hidden Injustice in Canada. And we're really excited to be able to participate in this launch, and thank you both for coming today.
Thank you for the introduction. It's our pleasure to be here today to launch our report. The project was funded by a SSHRC Partnership Engage grant and conducted with our community partner, Romero House in Toronto. The Center for Refugee Studies and the Refugee Law Lab have generously supported work on this project throughout the process. So I'm really pleased to be able to share the findings with CRS and Refugee Law Lab audience. I also want to join Michaela in acknowledging the lands where we live and work and where we conducted this research and where we're gathering here today, whether virtually or in person, to acknowledge our obligations to care for the land and water that sustain us, and to acknowledge also our obligations to address the ongoing harms of colonization here on this land. Two notes that I want to share about language. Throughout the presentation, we're going to be using the terms deportation and removals interchangeably. The legal term for the process at the heart of this study is removals. In law, deportation has a distinct definition referring to a specific type of removal order. For those who are lawyers or law students or trained in law, I want to be clear that when I'm saying deportation, I mean all types of removals and not specifically people who are removed by a deportation order. But because removal has sort of an impersonal administrative connotation, it can obscure the fact that we're talking about the forcible relocation of people. So for that reason, we like to avoid the legal terminology and address it more directly as deportation. But at the same time, the word removal is found in government documents and data. So the word removal does kind of slip in sometimes, but I'm kind of using them interchangeably. And a second point about language. I refer to people who are affected by this process in a few different ways. So people with a previous refugee claim, but also sometimes I use the term refugees. When I say refugees, I mean people who self-identify as having fled from a country where they fear persecution, rather than specifically people who were granted legal status and recognized as a refugee. So when I'm using the term refugees, I'm adopting the view of the person about their own fear rather than a state-centric view about whether or not that fear is considered to be valid. And so the other thing I wanted to say is that our study is really very focused on people who continue to fear return. So that's sort of the focus or the framing of the study. So just to share the agenda, we're going to start by talking a little bit about the research, why we did the research, how we did the research, and then, what we're going to be doing with the research starting today, which is kind of the launch day, and going forward. And then we'll get into the findings, and we've really identified 3 areas of findings that we want to share in the talk today related to the process itself, the timeline, and then things that limit the ability of people to navigate the system in a meaningful way. So I want to start by asking a question. Why study deportation? People who made a previous refugee claim in Canada are, according to CBSA documents and the CBSA departmental plans that are shared with Parliament each year, a priority group for enforcement action. And CBSA organizes its efforts accordingly. More than half the people deported from Canada each year are people who previously made a refugee claim. Deportation is a relatively opaque process. There is very little public information about deportation. There's also little public discussion about the deportation process, why we deport people, how many resources we devote to deportation, and how much force would be acceptable in using in order to enforce a deportation. CBSA operates with no independent oversight body, something that may change under the current Liberal government, but we'll see how that proceeds. And the lack of oversight contributes to the relatively quiet way in which deportations proceed. The deportation process is also underexplored in academic literature. The theoretical implications of deportation for statecraft, sovereignty, bordering, and the production of so-called illegality have been studied fruitfully by scholars, but there's much less literature on the process itself, the specific assemblages of actors, mechanics, routines, and techniques. And this is particularly true in the Canadian context. But the how of deportation matters, not only in studying power at its point of application, as Foucault calls us to do, but also in the very practical sense. Considerations of how to deport people inform the design of the refugee determination system. It's not something I'm going to talk about a lot right now, but we can talk about it in the Q&A if you want. And furthermore, the how of deportation matters because the consequences of misunderstanding it are severe. If people don't understand what is happening and they make mistakes, they end up getting deported. A lack of transparency interferes with fairness and the actualization of refugee protection, hence the subtitle for our report, Hidden Injustice in Canada. The purpose of this research project then was both to address a knowledge gap of a non-academic partner while also making a hidden process more visible. Scholars like Grace Cho and Nancy Heemstra caution us that invisibility should not be easily accepted because invisibility can allow for the reproduction of violence and harm. Bringing visibility to the deportation process can undermine some of the unpredictability, the chaos, and the opacity that are serving currently as a space of action for government officials, including CBSA officers. So our goal is to enhance the capacity of individuals, legal representatives, refugee support people, and advocates to navigate the system in order to protect refugees from deportation. I also want to consider the issue in one more way. Why study deportation specifically in Canada, a country that prides itself in the procedural protections built into the refugee determination system and prides itself as being a model for other countries? If Canada's system is considered a model, then it's all the more worth asking, how is it going? And the answer is, I would say, we don't really know. We do know, based on the work of people like Sean Ray Haig and Hilary Evans Cameron, that decisions on refugee claims can vary depending on various factors. So they can be wrong. So some of the factors that influence the outcome are things like the quality of legal representation that you have, the board member who hears your claim, the availability of evidence to back up what you're saying, and determinations about credibility, which are subjective at the end of the day. Some people who are at risk of persecution, torture, and worse can be incorrectly denied refugee status and put into the deportation process. So for these reasons, the deportation process is linked to refugee protection and the refugee determination system. There is a scene that plays out many times each year in the offices of refugee support organizations across Toronto and presumably across the country. A person comes in the door and they says they're from a country where there is persistent conflict and political violence. They lost their refugee claim months ago or maybe years ago. They're due to be deported imminently, sometimes in a week, sometimes they even say, I'm due to be deported tomorrow. But they're in danger in their home country and they need help. These incidents raise concerns. What led them to cooperate with their deportation process to this point? In some cases, having even bought the plane ticket that they're supposed to be leaving on, that they're now saying that they can't get on. And why didn't they seek help earlier to stop their deportation? What can be done now to help this person? Because the timing of interventions can really matter. And how many people never seek help at all and find themselves on an airplane to a country where they fear persecution? Deporting someone to persecution is catastrophic, but the deportation process wasn't designed to prevent this outcome. CBSA's structure and mandate are oriented around enforcement rather than human rights or fairness. And this design shapes the conduct of CBSA officers accordingly. To understand how the deportation process works and the factors that inform the process, we looked at it from two perspectives: that of the government officials who design, revise, and implement the deportation process, as well as knowledge of the system held by people such as legal representatives, refugee support organizations, and advocates who regularly interact with it. In our analysis, we privilege the perspective of those who are interacting with the system, following the advice of Alison Mounts to study up. Despite this imperative to study up, the government perspective on deportation was important to answer questions about how the deportation process proceeds and why. So to understand the process, we examined government data, including making about 30 access to information and privacy requests, or ATIP requests, for statistics on the deportation of refused refugee claimants, government documents such as memos, job descriptions, performance measures, things like that. We interviewed a former deportation officer and talked about things like the training, the role, and what happens when people are called in for pre-deportation interviews. We also interviewed 19 legal representatives and 4 community organizations who work in Ontario and are experienced with deportations. So we really focused on legal representatives who are really experienced in the area. That was the kind of specific perspective we were trying to seek, not sort of a general understanding of within the law profession. While much of what we have to say has national applicability, there are some aspects that are province specific. So in particular, the availability of legal aid depends province to province. Also, the availability of things like legal representation and support organizations can even vary community to community. There's also variation in the institutional culture of CBSA regions, which affects how people are treated during the process, and also the success rate of deferrals for removals, which are, as I understand, decided regionally. So I wanted to talk a little bit about, what we're doing with the project or where we're going. We wanted to bring the findings to different audiences, and to do so, it often requires different outputs or different publications. So to that end, we're launching 3 things today. One is a report. The other one is a kind of double-sided brochure, as well as a data repository. And a lot of what we're going to be talking about today are the things that are in the report. So in the report, we lay out our findings and recommendations. The first half describes the deportation process and the timeline, as well as commonly used legal options to get permission to stay in Canada. And the second half demonstrates how unfairness is structured into the deportation process. And in that section, we consider macro factors like CBSA's structure and mandate, as well as individual factors such as conduct by individual CBSA officers and, unfortunately, misconduct. I brought a few copies of the brochure, which I will pass around, and it's also available online. And I also want to talk about why the brochure is so important. There's 2 reasons that it was really important to make the brochure. The first is that it lays out in plain language what happens during the deportation process. And a lot of this information hasn't really been available or pulled together in one place until now. But it's important to acknowledge that the deportation process is complex, and there's a limit to what can be said that's generalizable. So part of what the brochure is saying is to really encourage people to reach out and ask for help, and to ask for help the earlier the better, to try to intervene in that kind of situation that I described earlier in the talk about people trying to seek help, only a couple of days before the deportation. So the idea is to increase people's access to information, to encourage them to ask for help, to give them a sense of some of the things they might want to know or ask about when they're seeking help. But there's also kind of a bigger point to the brochure, which is that I think what we hear is that there's a lot of people who are afraid to ask for help. They feel a lot of shame around the idea that they've been refused refugee status, that they're in the deportation process, that they're maybe trying to not be deported. And so I think part of it as well is that if you're given the brochure, or if you see the brochure on a website of an organization or a link to the brochure, that it gives you the idea that you can ask people for help and information, and hopefully, even further to intervene again in the kind of situation I described earlier in the talk, so that people feel like this is an issue that we can talk about. Since transparency isn't the current state of affairs, we also wanted to make available the government data that we received during the research. We've analyzed this data, we've used it hopefully in ways that you'll find interesting if you have a chance to read the report. But inevitably, there's other ways to use the data, there's other ways to analyze it. And at its core, it is public data from a government institution. And so it doesn't really belong to us per se, but it sort of belongs to, I don't know, the public of Canada. So we wanted to make available the data that we got through our ATIP requests. And so that's the purpose of the data repository. The data repository is hosted online on the Refugee Law Lab website. It covers 5 topic areas, which I've listed here. And I also provided a little bit of information about how to make your own ATIP request, or how to explore ATIP requests that have previously been made by other people, because it's quite easy to get copies of other people's ATIP requests. So I included those links there. And I do hope it inspires you, if it's relevant to your research, to make your own ATIP requests as well. So, do you want to pass out? Sure. There's a couple of them so people can have a look. This is the 2-page brochure. And some of the content there is about to be on the screen. So you'll see. I don't know. Do you guys all want one, or do you just want to pass it around? I wasn't sure what to do with them. There you go. Yeah, so that's a good question. It's on the Romero House website because that's our community partner. There probably aren't links to it on the talk. No, they are not.
Can we maybe put a link on the CRS? You can put a link on the CRS or the Refugee Law Lab web.
Yeah, I think I actually didn't put it on the data repository.
Yeah,
that's maybe silly. All right, maybe we'll figure it out. We'll figure it out. We'll put a link somewhere. I don't know if you want to. Well, I have the computer. I was going to say we could type it into the chat, but I definitely cannot type and talk. So, do you want to try to do that? Yeah. All right. So, hopefully that will give access to the people who are.
Well, everybody who's registered, we'll send you an email where you can find the link.
Oh, okay. All right, and Brianna might get it into the chat one way or another right now. Okay, so one of the things that we did is we asked a graphic designer to work with us to illustrate the basic elements of the deportation process. And what we did is we made this timeline, which is here, and it's also on the brochure. And we divided the deportation process into 3 stages: the waiting period, the action period, and the outcome. And what I'm going to do for starters is to walk you through the phases and kind of explain a little bit more about literally what happens and why. After the case has been refused and there are no more rights of appeal, people enter the waiting period. The duration of the waiting period varies significantly. Some people are contacted by CBSA within weeks. For some people, it's months. It can even be years. And there's no discernible pattern in terms of how long it's going to be before your deportation process is initiated sort of by CBSA. The waiting period is understandably very scary for a lot of people. People don't know when enforcement action is going to begin. And for people who fear return, it's really frightening. The problem is the only thing worse than uncertainty about when it's going to begin is certainty, because the only way you get certainty is if it begins, and that means that they're actively trying to deport you. So the unpredictable duration of the stage 1 is something that we set out to explain in the research project. What we found is this: the waiting period occurs because of the involvement of numerous people and processes. It's a bit of an unsatisfactory answer, but also one that you can imagine really fits with the idea of a big bureaucracy. Depending what applications and appeals have been lodged, all or part of your file may be with Immigration, Refugees and Citizenship Canada, or IRCC. It may be with the IRB, the RAD, which is the appeals division, or the federal court. The information is not always transferred between agencies in a timely manner. We also know from interviews and from government audits that technology for file sharing across agencies and case management software are relatively poor. So that makes it more challenging to transfer the files. Also, some of them are mixed between an electronic file and a paper file, which further complicates the issue. When CBSA receives the file, CBSA managers should assign it to a CBSA officer. But according to the Auditor General, in a representative sample of cases that were not removed within 1 year, about 1 in 5 were not assigned to an officer. So they're not always getting assigned right away. There doesn't seem to be a pattern to that either. Once the case is assigned to a deportation officer, officers have discretion in deciding which cases to work on first. They might choose to work on the easiest cases or the ones that fit into some kind of priority. So there's different ways they might make decisions about which cases they're going to be working on. And part of the idea of all of these is just to show how complex it is. I hope they're big enough to read. But errors in the CBSA database make it even more difficult for officers to decide. For example, if they want to prioritize an easy case, how do they decide what's an easy case? They look at the kind of file sharing, the database, but there's a lot of problems with the database. So the Auditor General identified cases where electronic files don't have key documents in them. There's also cases that are missing from what's called the removals inventory. There's some cases that are considered actionable, but are labeled in the inventory as inactionable, and vice versa. There are cases that are inactionable, but they are marked in the system as actionable. So basically the quality of data management and case management and the files is not great at the moment, although they are investing, as I understand, a significant amount of money in IT upgrades. So we'll see, I guess, how that plays out. People know that their case is being actively pursued when they're invited to come for their first interview. So that's how you know that they're working on your case. A former deportation officer described the overall process of the action phase as having 5 steps that are addressed in order, although he also said that not every region follows that order or that procedure. And I put the 5 stages there, which is, verifying the travel document, obtain one if there isn't one. We're going to talk more about travel documents in a few minutes. If someone is eligible, to initiate the pre-removal risk assessment, then to give them the decision. And then at that point, that's when you kind of schedule the date for the deportation and talk about, who's going to pay for the plane ticket and all those kinds of things. In the first interview, the officer verifies people's identity, their personal information, and they check to whether it matches the file. As I've previously described, there's a good chance the information that they think they have or they think they know doesn't match the file. They also check to see if that person has a valid travel document. And in that appointment, they'll instruct people on what the next steps are that they need to take. And then if there are subsequent appointments, they will verify that people are complying with the instructions they received. So for example, they might be asked to get passport photos, or they might be asked to apply for a travel document. They might be asked to get passports, other things like that. Sometimes they're asked to buy their own plane ticket. So then when you come in for your subsequent appointments, they're checking to make sure that you've taken the steps that were asked of you and that you're continuing to comply with CBSA instructions. For people who fear return, early access to experienced legal representatives plays an important role in enabling the use of legal options. Some refugee lawyers don't do this kind of work, this kind of removals work, and other refugee lawyers are limited in how many such cases they can take. So it's not always easy to find a legal representative to take your case. That can take up your time, for one. Legal representations to be granted permission to stay in Canada or to delay deportation are really complicated, and they do take time to put together. So even once you have someone working on your case, it takes time for them to actually make those representations on your behalf. But anecdotally, we do hear that shame about being refused refugee status and being in the deportation process. And just sometimes people are caught in kind of a fog of fear and inaction, and that can inhibit people from asking for help. So that leads to these kinds of situations where people are asking for help at the last minute. The report also includes a description of 4 commonly used legal options, either to delay a deportation or to get permission to stay in Canada. And we also present some data that we got from IRCC about the success rate of those legal options when they're specifically used by people with a refused refugee claim. But in the interest of time, I'm not going to go over that data today, but if that's something that interests you, it is in the report. So I'm going to talk a little bit about timing and duration and why the timing of the process matters. For starters, I'll say that in the years that were included in the study, which is between 2013 and 2020, deportations occurred on average about 1,000 days after the refugee case was refused. But as I said before, it can really vary. It can be very short. It can be much longer than 1,000 days, but that's the average. But the Canadian government is significantly invested in speeding up the deportation process because a fast process is more likely to result in a deportation. So to achieve this goal, the Canadian government made legislative changes designed to accelerate the refugee determination process and restrict access to immigration applications made by people with a refused refugee claim. Because timelines of removal is a significant focus, CBSA also measures its performance in terms of how many people are removed and how quickly they are removed. So this duration from when you got your refusal until when you are deported. So why does the speed or what CBSA calls the timeliness of removals, and that phrase appears a lot in CBSA documents, why is it that the timeliness of removals matters? Speed of deportation influences the outcome for 2 reasons. Firstly, because people who stay more than a year in Canada have access to more legal options. So they're more likely to be able to access an application on humanitarian and compassionate grounds, what's often called H&Cs. And also then they're able to access a pre-removal risk assessment or a PRA. And secondly, because the availability of a valid travel document significantly impacts CBSA's ability to deport people. So for example, a 2016 evaluation of refugee reforms states that countries delaying or refusing issuance of a travel document to facilitate deportation accounts for 3/4 of all cases that are considered to have what's called impediments to removal. Travel documents are more likely to be valid if the deportation happens sooner after the person enters Canada and makes their refugee claim. If the travel document is expired, CBSA will ask people to make an application for a new travel document, but some countries are routinely uncooperative. We have indication from government documents that we received that CBSA has put together a list of quote unquote difficult to remove to countries to help them assess the level of case complexity in the removals inventory. We requested a copy of that list. They haven't given it to us yet. I hope they will someday. We'll see. But from research participants, we understand that some of those countries that are routinely uncooperative could include Cameroon, Gambia, Guinea, India, Nigeria, and Pakistan. Those are a few examples. CBSA anticipates that difficulties obtaining travel documents will continue to prevent deportations. According to the 2015-2016 Departmental Performance Report, they said a significant portion of new claimants are from countries where it's difficult to obtain travel documents. Therefore, the cases that enter the removal stream in the future will be difficult to remove. And so one of the things they're also doing is working on increasing the number of countries who cooperate with deportations, and they try to sign memorandums of understanding with various countries. I think the list of, I don't know. I have the list. If it's not available online, I do have the list somewhere. So to summarize everything that I've said so far, to summarize the discussion specifically of duration and timing, once someone is in the deportation process, the level of risk they face upon return may not be the most significant factor in determining whether they are deported. Rather, it's things like validity of the travel document, whether or not their country of citizenship cooperates, their access to legal representation, and quite frankly, the random chance of staying in Canada long enough to be eligible to submit an H&C or a PRA. Like, these are the things that really influence the outcome of the deportation process. So with that, I'm going to hand it over to Brianna, and we're going to do a little seat switch.
Right, I click first. So as Catherine just outlined, it's really things like duration, timing, and really the unpredictable nature of the whole deportation process that all come together under an organization whose mandate prioritizes fast deportations and timely removals. So this really creates the conditions that result in unfair outcomes. So in the second half of our report, we demonstrate how unfairness is structured into the deportation process and outline roughly 7 different factors that are illustrated in this figure here, and this figure is also in our report. So what I hope to do for the remaining presentation time is outline how the opaque nature of deportation, which was one of the driving motivations for this research, also revealed itself as a main finding to further explain unjust outcomes of deportation. So our interviewees told us that it was really common for their clients to come to them totally confused and not knowing what to expect during the deportation process. In the slides to follow, I will draw on the specific factors of an overall lack of information, the lack of interpreters that's provided during the pre-deportation interviews with CBSA, and the spread of misinformation about the process and legal options available, all of which obscure the deportation process and contribute to chaos. So I'm drawing on the concept of chaos as found in Nancy Heemstra's work, where she says that chaos is not entirely careless as it may seem. That is, the lack of cohesion and transparency within the detention and deportation system is highly effective in obscuring migrants' alternatives to deportation. In addition, due to its disorder and confusion, the D&D system projects a cloak of impenetrability that hides both its faults and the driving influence of the immigration industrial complex. And so in our specific study, chaos is produced by way of a lack of cohesion and consistency of information, the lack of transparency about the process, and even in the lack of honesty about options that's available. So chaos here has a peculiar structural advantage in that it creates a productive space for statecraft where decision makers can fulfill a mandate that prioritizes the numbers of removals over human rights. Or to put it a bit differently, chaos has this particular structural advantage that shapes deportation outcomes so that they're not necessarily based on risk, but instead raise questions surrounding adequate access to justice. And so the first factor that contributes to chaos is the overall lack of information. So as Catherine mentioned at the beginning of the talk, publicly available information is really limited in terms of what the deportation process is. So there's 2 CBSA web pages that provide just a general description of deportation and the types of deportation orders, but neither web page is aimed at informing people in the deportation process about what is expected of them or what options they have to try to stop or delay deportation. So our interviewees really, reiterated this fact that people seem to be unaware of their legal options to stop or delay their deportation. To quote Morris, a refugee lawyer, he emphasized that deferral requests, which are one of the legal remedies that are supposed to be available to people, are unpublicized. They're not on the immigration website. Officers don't tell people about deferrals often. It's not set out anywhere. So this matters because people's understanding of the deportation process is necessarily going to shape how they negotiate or navigate it. So for example, we learned that a common mishap amongst people is, as one of our interviewees put it, not knowing when to turn refugee mode off, especially during the interviews with deportation CBSA officers. So while it might seem logical to tell deportation officers that they fear persecution, that they don't want to go home, in order to kind of, communicate the level of risk that they face if they were to be deported, this is actually a miscalculation since the deportation officers don't have the authority to actually determine whether or not somebody is removed or not. So the CBSA officer's role is really just to plan and enforce the deportation, but they don't necessarily have the authority to determine, for example, new risk that would be considered in a pre-removal risk assessment. So instead, expressing fear only increases the likelihood of being perceived by CBSA as a flight risk, which is the grounds for them to detain the person. So Ezra, an immigration consultant, explained that some people will cry and beg in pre-deportation interviews, and it means they get detained because the officer thinks they're not going to show up. Language barriers also deepen the confusion and by extension, the chaos of the deportation system. So CBSA does not provide interpreters during the pre-deportation interviews. And so what this means is that if somebody needs interpretation services for these appointments, they have to go to their own networks and find somebody to help them. So our interviewees worried about how much people understood the content of the interviews. And so it's hard to know whether the CBSA officer is kind of just vague in the information that they give, or whether it's because clients just struggle to understand what's happening during these appointments. The worst outcome that we learned of, according to interviewees, was people being forced to rely on their children to interpret in CBSA interviews. So Shelley called the use of children to translate devastating, going on to say that it's a huge issue. The fact that they don't have interpreters is ludicrous. I would suspect that the vast majority of people don't speak English or French as a first language. They may have some working knowledge of one of those languages, but not enough to understand the complexities of what they are told. So lack of translation further prevents non-English and non-French speakers from understanding the options that are available to them. The third factor that contributes to the opacity and chaos of the deportation process is misinformation. So misinformation was actually characterized by our interviewees as a form of misconduct, and it was the form of misconduct that was most often named by them. So we learned that officers gave misinformation about a range of topics, including the reasons for an interview, the availability of legal options, the success rates of these legal options, and even the value of legal representation. So the misinformation sometimes seemed to stem from ignorance and a lack of training on the part of CBSA officers, but other times misinformation seemed like a deliberate tactic to interfere with people's ability to contest their deportation. In terms of the misinformation that was perceived by our interviewees as unintentional, it was largely attributed to things like lack of training. And the data that we pulled from government documents really supported this. So for example, a 2016 audit of immigration enforcement identified that the removals chapter, which is used by CBSA as guidance, hadn't been updated in 7 years, despite significant legislative changes and changes to policies and procedures. So ultimately, this lack of clarity about how to interpret different legislation and about the lack of clarity surrounding policies and procedures leads to uneven application amongst CBSA officers. There's also the disorganized chaos of the job, which was really highlighted by the former CBSA officer that we interviewed and to which Catherine alluded to earlier. And so when describing their first day on the job, the former CBSA officer we interviewed shared that they sat me at a desk and said, here's your files. If you have questions, ask your colleagues. Training-wise, it's not structured in how they teach removals officers to do their job. You learn by practice. You learn by sitting with someone and watching them do it. So this really means that good or poor conduct can easily get transmitted from officer to officer. The management structures that are in place as well are not necessarily designed to ensure good conduct. So managers of deportation officers are chosen based on their qualifications of being a manager and not necessarily for their expertise in deportation. So only some of the former CBSA officer, only some of their managers were familiar with deportations. And they shared that my removals manager was not a removals guy. He had no idea what removals were. He was just the manager. Some of our interviewees expressed, however, that misinformation did seem intentional. And so returning briefly to Nancy Heemstra's work, she discusses how unintentional chaotic structures, like in our case, the misinformation that's spread by lack of training, also dangerously interlock with more intentional structures of the immigration industrial complex. So in our study, these more dangerous intentional structures are structural racism and the priorities of many timely removals. So performance measures such as the number of removals or timeliness of removals, can incentivize CBSA officers to act in unfair and unjust ways in the removal process. So our report documents chronic problems with misconduct by CBSA officers, where we learned from our interviewees about persistent incidents where officers were intimidating vulnerable people, misinforming people about the deportation process and their legal options, and even concocting documents in order to enforce a removal. So misinformation here really serves CBSA's mandate, which is to enforce deportation rather than prevent refoulement. Numerous legal representatives pointed out to us that misinformation about legal options helps officers meet their performance targets. Satya, a refugee lawyer, said, people are kept in reactive mode, so they can't prepare for deportations. So people don't know enough about the process. So people are ignorant of their rights. I think it's a tactic by CBSA to keep people in the dark, to keep people ignorant of their rights so they can more effectively deport. Interview participants had also encountered cases where officers do not inform people of their eligibility for a PRA or pre-removal risk assessment, or they actually discourage some people from submitting a PRA application. So depriving someone access to legal options can cost lives. The damage of misinformation was most clearly illustrated by Benjamin, a refugee lawyer, in a case that he handled where a CBSA officer lied to somebody about the implications of not seeking a PRA. So the person was told to waive their PRA, and the officer said only 1% of PRAs are accepted, so it's a waste of your time. If you waive your PRA, we will permit you to travel on your own. Whereas if we need to enforce your deportation after a PRA, the country name government will be notified about your arrival. We know that you're scared of that, so you might want to waive it. And the person did waive the PRA. Nevertheless, their documents were given to the flight crew, and the flight crew gave them to officials on arrival in the capital city. The person was arrested and tortured for 2 months. There was additional evidence that could have been considered on the PRA had it not been waived. All of that was a result of CBSA manipulating and lying to the clients. That was one of the most horrifying cases. So in this case, CBSA enforced a deportation that should not have happened, and CBSA conduct led to somebody being tortured. This case is unusual since a Canadian lawyer was able to find out what happened to the person after they were deported, but the Canadian government doesn't have any official mechanism in place to know what happens to people after deportation. And so the government does not know how often errors or misconduct lead to persecution. In all, the resulting structure is one of unpredictability, confusion, opacity from the lack of or from misinformation, leaving in its midst important consequences for people in the deportation process, including nearly their eventual guaranteed deportation. But as Heemstra reminds us, the chaos actually also offers cracks through which change may be affected. For example, we can work to increase the information that's available to people and the legal assistance, and draw attention to taxpayer dollars that are wasted due to inefficiency of the process, subjective criteria for detention, and the deportation of people who shouldn't be. So on this note, our report concludes with 13 recommendations in total, 11 of which are directed to the Government of Canada, and 2 of which are addressed to people who work with refused refugee claimants, or who work with refugee claimants. So for time purposes, I won't go through all 13 recommendations. I'll just highlight some of them that, a few that are relevant to our talk today. So in terms of the Government of Canada recommendations, to address more of the temporal dimensions of chaos that Catherine spoke about in terms of timelines and duration and unpredictability, we recommend to repeal the 1-year bar on PRAs and H&Cs, and to end the deportation of people with a refused refugee claim who have submitted an H&C application. We also recommend to increase the period between last refusal and deportation. So currently, people are required to leave Canada within 30 days of the last refusal of their refugee claim. CBSA sometimes will begin the deportation process within weeks of receiving this negative claim, negative decision. So this does not leave nearly enough time for people to be informed about the process and to make decisions about how to proceed. To address other elements of chaos, we recommend to provide clear information about deportation at the beginning of the process. So as we demonstrated, lack of transparency makes the deportation process less fair. And so people should be given information about what legal options are available to them and how to find a legal representative at the beginning of the deportation process. Secondly, after each pre-deportation interview, people should be given written information documenting what next steps are expected of them. And information should also be available in multiple languages. Related to this, we recommend that interpreters be provided for these pre-deportation interviews, since people should understand what's happening in these appointments. Even more so, the use of children as interpreters during these appointments is inappropriate and violates the best interest of the child. Finally, we also recommend to create an independent oversight body for CBSA or any department that is tasked with deportations. This is by no means an original or groundbreaking recommendations. There have been many people who have already very well elaborated kind of the qualities that are needed in an oversight body, including the Canadian Council for Refugees and the British Columbia Civil Liberties Association. So it's crucial that those qualities be taken up to create an oversight body that can compel evidence and make binding recommendations. In terms of the recommendations for people who work with refugee claimants, we wanted to tackle ways that encourage building collaborative networks amongst the cracks of the chaos, as well as removing shame from the process so people feel empowered to be informed. So to this effect, we recommend that people who work with refugee claimants develop relationships with legal representatives and support organizations that hold expertise in the deportation. And we recommend to tell clients that they seek assistance after the refugee claim has been refused and even after they have no more right of appeal. So with that, I will just thank you all for your attention today, and Catherine and I look forward to your comments or to answering any questions. We stop sharing the
Sure.